Our next defence looks at fair comment and honest opinion. So how far can people go in discussing particularly matters of public importance where they're putting their own opinion on the line? What if that could potentially be defamation? The defence of fair comment is common law defence, and it's sometimes also called the defence of honest opinion. It's available to protect things like criticism, analysis, editorials, etc., on matters of legitimate interest to the public. That is, not on scandal, not on the private lives of the rich and famous, but on matters of legitimate interest to the public. The elements of the common law defence are that the defamatory matter is comment, that when we look at the Act, you'll see they talk about opinion. Then it must be based on true facts. It cannot itself be a statement of fact. It must be based on facts, and here's the opinion. The defendant must show that the comment was on a matter of public interest, and they have to show the comment was fair. And if there is malice, then this defence is not available. So what about the statutory defence? Section 31 has the defence of honest opinion, and it says it's a defence to the publication of a defamatory matter if the defendant proves that the matter was an expression of opinion rather than a statement of fact, the opinion relates to a matter of public interest, and the opinion is based on proper material. So you can see there's some similarities with the common law there. It's got to be a matter of public interest, it's got to be opinion here rather than comment, but also based on facts, and it has to be based on proper material. If you have a look at sections 31.2 and 31.3, you'll see that it also covers publishers for statements by their employees. So for example, a TV station with its employed commentators, or where the comment is by another person and it's repeated by a publisher. So for example, where someone interviews someone and that person makes a statement of comment, of honest opinion, and that is published by, for example, a roving reporter. So we're going to look at some of the commonalities and then how the courts have interpreted them. As you know, the common law required a comment, and the Act required an expression of opinion rather than a statement of fact. For common law, it must be a comment and cannot be a statement of fact similar to what is in the Defamation Act. So it's got to be an opinion. It can't be a fact. So what does that mean? In the early case of Clark and Norton, they said that an opinion was a deduction, inference, conclusion, criticism, judgment, remark, or observation, and not a direct statement concerning or description of a subject of public interest. So you take a fact, you state your opinion about it. It's an objective test. And so in Channel 7 Adelaide and Mannock, they said, would an ordinary reasonable person take this to be a statement of opinion or a statement of fact? You have to generally have shown the facts. So if the defendant just makes a statement, e.g. Mary's comment is deceitful, that will be considered to be a fact. Yes, it's got opinion wrapped up in it, but it's implying facts that Mary has behaved in a way which is deceitful, and that she has done things which are lies or otherwise deceitful. So that would be taken to be a factual statement. On the other hand, if a person sets out the facts and then makes their statement about Mary, then it may be an honest opinion. So if someone said, Mary hides all the books relating to intentional torts, and she lies to all her classmates about where those books are, her conduct was disgraceful, or even her conduct was deceitful, that could be an opinion. The facts are stated, and then the statement is an opinion based on those facts. So where your client has stated facts and then commentary on them, that will make it easier to prove that it's a matter of fair comment or honest opinion. An example of this was the case of Hawke and Tamworth newspapers. This relates to the former Australian Prime Minister, Bob Hawke. And a letter to the editor was published by the Tamworth newspaper. And it said something like, ironically, I could have Hawke banned from this or any other election quite easily, but I'm not saying how. Hawke, of course, sued the newspaper, claiming that this was defamatory. The newspaper ran a defence of fair comment or honest opinion for the publication of this third-party letter. They, of course, were a publisher because they reproduced the information and published it to other third parties. And of course, the original letter writer could also have been a publisher of the letter by sending it to the paper. The court held this was an assertion of fact, that there are reasons why Hawke should be banned from elections, rather than a comment. A reasonable recipient would have taken this statement as a fact because there were no actual facts in it, it's implying facts. Then they imply the fact that the defendant could have further information which makes Hawke unsuitable and could in fact have him banned from running it for an election, rather than being a statement of opinion, for example, calling for his banning from elections on the basis of a range of facts. The court said for it to have been based on facts, you would be looking at things like saying that he's unfit to be a member of parliament, opinion, because he is an alcoholic or an adulterer, facts. That was not what was in the letter. By implying facts, that became a statement of fact rather than a statement of opinion. The next thing you need to look at is that the comment was for a matter of public interest. And again, in the Defamation Act, it talks about public interest. Again, that means not things which the public is merely interested in, scandal, improper purpose, but rather that which advances public discourse, etc., and so is a matter of public interest. The comment must be fair under common law or must be based on proper material under the Defamation Act. If you have a look, there is some listing of proper material, and that means when you look at the subsections that it's actually based on the truth, or it's based on documents which are subject to absolute or qualified privilege. So that's a proper basis for an opinion. It doesn't have to be a completely well-reasoned opinion, but it does have to have a proper basis under the statute, or, however biased or prejudiced, have been an opinion based on a fact which can be proved. So if you show the fact and that opinion could reasonably be based on it, or could be based on it by an honest person, then that would be a fair comment at common law. The defence, of course, is defeated if you prove malice, and I've talked about what is malice in some of the other videos. Similarly, so it's malice at common law. Under the Defamation Act, it's defeated if and only if the plaintiff proves that if it's a defence to subsection 1, the defendant themselves has made the statement of fact, then they must show that the opinion was not honestly held by the defendant at the time the defamatory matter was published. Malice will usually show that, because if they're making the comment for an improper purpose, they may not be properly holding the opinion. There's also similar ways to defeat the defence if the defendant did not believe that their employee or agent held the opinion, if you're suing under the defence, if they're using the defence relating to an employee or agent, or if they're using the defence in relation to a third-party commentator, if the defendant did not have reasonable grounds to believe that the opinion was not honestly, if the defendant had reasonable grounds to believe the opinion was not reasonably held by the commentator, then the defence can't be used and they won't be successful. So that's it for fair comment and honest opinion.